Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome back to an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney. With Joseph Jordan, I am your host, Mike Leon. Joseph here is the founder of the Jordan UCMJ Law Group and a former Army JAG and worldwide court-martial defense attorney who's tried more than 240 court-martials to verdict, and he's handled thousands of military cases all across, not only here in the U.S., but the Middle East, the Pacific, Europe, and beyond. Today's episode, we're going to be talking about closing arguments, right? One of the most important things in a trial, Joseph's going to explain. But the moment when everything that's happened in the courtroom either comes together or it falls apart. Joseph, it's good to see you as always, my friend. All right, so now we've reached closing arguments. The panel has already kind of lived with this case for days. It's been in their ethos, right? What are you kind of paying attention to as you stand up to kind of give that closing argument, and what does that tell you before you even say a word?
Well, you don't really pay attention to much because the cards are in. So your closing argument's prepared. So you're listening to the government counsel's argument to hear, is there anything in particular I want to exploit? Otherwise, you already know what you're going to say. And you want to keep it in line with what the panel has heard. You don't come in there with smoke and mirrors. You come in there, you argue the hard, cold facts and explain them in a manner that makes sense to the panel and gets your point across on behalf of your client.
Well, speaking on that front, because obviously at the closing statement, it's the finality of the trial almost, and so you don't really want to introduce anything new. How are you choosing which parts of the trial you kind of want to harp on, you want to bring back, which ones you kind of want to leave out?
When I look at closing arguments, I first start with what the jury instructions are going to be that the panel is going to receive from the judge. And then I start looking at what are the indisputable facts of the case as presented. And once I define what the indisputable facts are, now we start to look at the points of contention. And from there, you're looking at motives, you're looking at bias. When I say motives, I'm looking, in a domestic violence case or a sex assault case, or murder case, you're looking at motives to fabricate, motives to lie. And then you also want to focus on what everybody forgets in my business, which is common sense. What is the common sense factor here? What I find in courts is that the reasonable person wins in the courtroom.
So when you're in the closing arguments, let me just follow up on that. Like at that stage, what are you really trying to confirm versus persuade the panel to agree with you on?
Sure. What are the facts in dispute? And confirming those facts in dispute in such a way that they're tied to facts that are not in dispute. So you really want to bring through the common sense factor for what people live each and every day. What do they know in their own minds to be true? Why do people lie? What are the different motives that people might lie? And just kind of like general things that everybody experiences each and every day. And just tying that to the point that you're trying to make as you advocate for your client.
To that end, you and I have talked about this in previous episodes about emotion, and you've mentioned before how, you get right to it. You get a little blunt sometimes in the courtroom. Other lawyers maybe do it on an analytical basis with respect to the closing argument. Like how do you think about the role like the emotion should play, if any, at this point in the trials you're delivering that closing argument?
So that's a bit of a complex question because it depends on who I'm talking to, first of all. So if I'm talking to a judge, I don't need to be emotional. I don't need to have a lot of extra gestures and showmanship, as it were. Here's the facts, here's the law, here's why you find my client not guilty. The government hasn't met their burden, right? If I'm talking to a jury, though, almost always you're drawing some emotion, right? Because we're drawing on shared experiences to help tell a story. This closing argument is storytelling at its very basic core. Closing argument should be telling a story, your client's story, and why he's not guilty. Now, there may be certain cases where we're dealing with, white collar crime, for instance, some sort of fraud, right? And in those cases, I mean, there's not really a lot of emotions involved in something like that. So you keep it clinical, you keep it focused on the facts.
How about the other side of the prosecution? Like when they're delivering their closing argument, what are you kind of listening in for? Are you finding maybe things that they say that could potentially show that their case is vulnerable? And then are you emphasizing that in your closing?
I've already prepared the closing argument, but when I'm listening to government counsel, I will be looking at easy areas to exploit. Um, for example, if they use a slide deck and they misspell a witness's name, look at how much they care about the case, right? If they use a slide deck and they get the facts wrong, and I can verify that with my own evidence, great. Um, or if it's just a argument that they're making that doesn't make any sense, doesn't pass the smell test, and cuts directly against known facts. And a lot of times it's bringing the jury back to, hey, this is what this witness said. Remember that, because the government wants you to forget that.
So I'm sure then you have a temptation at times to kind of like respond to some of the things that they said directly in closing. Like, take me through, like, how do you kind of decide what stays in response to what they said versus, no, you know what, I had already scripted this out, I'm going to read this.
Well, it's less about responding to them. You never want to be put in a position where you're actually responding to the government's argument. You pick one salient point that you're going to respond to, you hit it, you quit it, you move on, you stick to what you've prepared. And sometimes what you can do, the more experienced counsel will pick a point and bury it within their overall argument, right? So like you've developed your outline, you know exactly how you want to execute your closing argument. They say something that fits or nests with a section that you've already prepared. Well, just bring it home. Hey, government said this in their closing argument. Let me tell you about that. So again, it comes back to, as I've always said throughout this series, mastering your case. Well, you master your closing argument, because when you're listening to what they have to say and you're looking through and reminding yourself on what it is that you want to deliver to the panel, you are thinking about, well, do I need to respond to that? Should I respond to that? Here's how I need to respond to that. You don't respond to everything.
Well, in that vein, can you share, obviously without giving the intricate details, but can you share a case where maybe you gave a closing argument, you felt it was less about performance, a little bit more about the alignment? Like how did you get that sense from the panel that you knew the panel was kind of already doing the work with you? What told you that?
So I want to talk about the case in Okinawa. In that situation, there was a lot of things that really lined up well. First of all, the government decided to put my client's statement into evidence. And the client's statement, there were some indications where he may have admitted to some conduct, but he didn't really, because of the way he was interrogated. The client would try to explain something, and then the agent would say, well, let me stop you there, because that's not what's important. I need you to tell me why you did this. That's what's important. Think questions of that nature, right? And when you force the panel to actually watch that interplay, they become more in line with the defense, in the sense that they're irritated with the way this questioning went. Doesn't seem real fair. And then when you cross-examine the agent and you sit there and you point out that the NCIS agent is permitted to lie to the client to draw out answers, well, that ain't great for the government, because the panel's not going to like that, especially in the Marine Corps. We had several really interesting facts come in. There was some technical aspects of this case that were really important, in the sense that there was a series of messages that were exchanged, and we look at the digital forensics and we're trying to determine what certain artifacts in the digital forensic report were and what they could be, and why these artifacts were sent along with messages, and why they weren't sent. And what we were able to determine was that the alleged victim, while she was allegedly being sexually assaulted, was sending out memes to a friend of hers. And I was able to draw that out from the agents, and through the use of my own digital forensic expert, as I consulted with him to understand this evidence. And so we look at those pieces of evidence. We look at how my client was interrogated, and at the end of his interrogation, you asked me earlier about when do you get emotional, when you don't. Well, sometimes the case allows you to just be emotional, because my client, at the end of his statement to NCIS, at the end of the interrogation, he's emotionally telling them, I said, I don't know why I thought this. I don't know why I thought that. Maybe it was because she allowed me in her room. Maybe it was because she was talking sweet to me. Maybe it's because she said I could sleep in her bed. Maybe she allowed me in the bed. I don't know why I thought it was okay, but I thought she was awake. I thought she was awake because she was into what was going on. She was reciprocating to me. That's why I thought it, and he is pleading with the NCIS agent, and you can see that it's not that he's pleading, but he is pouring out his emotion to the agent as he's describing what's happening to him. And how easy is that for me as an advocate to make the panel feel that again? Because that's your job, right? Make them feel that emotion so that they understand that's a true emotion. That's a true emotion that you can take to the bank and you can feel good about saying that Marine is not guilty.
Well, as we put a bow on this episode, and it funnels into this perfectly because as you've now delivered the closing argument, and we all are human beings, right? And there is emotion to this. Like, what is it ultimately from that closing that lawyers should have that panel when they go back to deliberate? Like, what should they have them stay with them, at least all the way throughout from the closing argument?
What is the core tenet of your case? What is the biggest point that is important, right? So what's the theme is what they like to say in law school, right? You're sitting there and you're saying, all right, you can't believe the alleged victim, and here's why. Okay? So you want them to go back to the panel and say, you can't believe the alleged victim, and here's why. 1, 2, and 3. So you want to give them some bite sizes, number one. Number two, I like to leave questions out there. Because who's responsible for answering the questions? The government is. They have to prove the case beyond a reasonable doubt. So I want to put in the panel's mind every reason possible why they should question the government's case. Because anytime they're questioning the government's case, that means the government hasn't answered the mail. They haven't answered the question. They can't prove it beyond a reasonable doubt.
Joseph, it's great stuff as always. Appreciate the time and the insights.
Thank you, Mike.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now. Visit jordanucmjlaw.com to connect with Jordan and his team. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.